This is a Canadian Lawmaker Gullible Taxpayer Guide to Notional National Debt and twice-paid tax credit Windbill conversion business case for a universal bank transaction control number. Part 4. The Tax Scam for the Rich Bank Effect. People bank personal incomes and life savings in retail and investment bank balances where they keep track of their money. The government manages monetary policy and the central bank clears private transactions while keeping public account of national affairs for the Treasury. Double-entry bookkeeping updates credit, debit, zero-balance, private cash flow and public revenue accounts across the banking system. Income tax returns provide public revenue streams that flow from private wealth in retail and investment bank account columns to public wealth accounts of money in circulation from the central bank. Tax payments in the Treasury public account is spent from the budget that tax investment codes stimulate the economy, which is the government tax credit spent business model with tax credit paid business from public cash flow in retail bank accounts. The government tax credit offset business model also stimulates investment in the economy that when thrifty people save personal income tax credits, public cash flows in private investment bank accounts. Tax credits redistribute wealth, and asset management in banking that advises profit from tax scams for the rich has become an election issue.
But imagine that someone seeking to be Prime Minister, Justin Trudeau, would casually assert and refuse to retract a statement that a large percentage of small businesses are just tax avoidance schemes for the wealthy. Friends, look around you. Here at TAMCO, there are 45 men and women building industrial equipment. Businesses like this are no tax scam.
In 2009, the government ABCP Crisis in Canada report documented my experience as a gullible taxpayer. I had unwittingly saved undisclosed bank loan income tax credits into personal financial ruin and notional national debt due to the ABCP acquire-to-distribute business model behind the largest $32 billion failure of a mortgage-backed securities financial conduit in Canadian history. The bank effect of unnumbered tax credit-saving loan accounts is that broken money bills collect private profits from public losses. My accountant advised government-incentivized investing, saving income tax credits to buy Allied Canadian managed rental income-producing commercial real estate sold in RRSP, Registered Retirement Savings Plans.
Financial advisor sales reps were bank-paid witness of tax savers signing promises to pay money for rent-encumbered mortgage credit default swaps, that Allied Bank agent property owner mortgage-backed securities dealer commissioner of oaths notarizes taxpayers as persons signing promissory notes for pre-executed loans accredited from statements of affairs for tax credits and private net worth for undisclosed, unsigned, unacknowledged loan application dependent sales.
The bank effect of secret commission sitting duck loans is broken money generators.
Tax bill revenue generators bill tax savers for tax savings payments, loan cash deposits, and mortgages bill renters for rental income payments that rent loss and tax savings, tax credit interest, LIBOR cost of money cash flows in ABCP financial conduits from ABCP Windbill tax revenue shortfalls behind ABCP bank windfalls.
In 2006, Broken Money Petition 44 was signed by NDP leaders Honourables Jack Layton and Andrea Horvath and many constituents to investigate bank signature-specific identity theft loans.
Hamilton Centre.
Thank you, Speaker. This petition is to the Legislative Assembly of Ontario, and it reads as follows: that an investigation concerning identity theft be conducted into banks, financial institutions and lending houses, lending policies, practices and procedures as per reopening OSC file number 200500316-17043 to identify weaknesses in the law and lending system procedures for appropriate amendments to the law to strengthen specific areas of responsibility for potential debtors' identity validation and financial due diligence that will safeguard people's wealth and equity in property from fraudulent loan applications, specifically in cases of third-party representation using notarized affidavits by or for loan handling lawyers that may benefit themselves and or their affiants. I am signing this, Speaker, and sending it to the table by way of Page Emily. Thank you.
The bank effect of secret commission-tied loan sales is broken money liabilities.
I sent you the letter saying this is how much loans forward, this is what the interest rate, those are the payments are, and you send in 12 both dated checks. Each would have been deposited into that account and then gone to pay the loan. Yeah, there's no account number, that's correct.
You have a liability related to the investment as well. It depends on the structure of the deal. All I'm saying is when you buy an investment, and some of these projects, the borrower, in our case, the investor, may have a liability related to the investment over and above the loan. If that's the case, the bank would include that in the debt servicing calculation. I never saw any evidence of that. May have been.
He didn't witness it. He witnessed Mr. Paris' signature. Mr. Paris swears an affidavit, and Mr. Emery commissions the affidavit. That's not witnessing your signature. Paris says he witnessed your signature, and here is a copy of it. Emery commissions it.
Clearly, it's your investment. You bought the units, right? You have a liability related to those now. You borrowed from the bank. You obviously have a liability with the bank. But there's no circle of funds going through some secret account.
The bank effect of broken money cash flow is broken money windfalls.
Taxpayers pay the ABCP rent-seeking tax arbitrage cost of money until ABCP property mortgages fail to roll over in default of non-performing mortgages and loans due to investment bank ABCP mortgage default swaps and retail bank court orders to collect unnumbered tied loans behind bank-acquired property and repossessed real estate.
Part 5. The broken money cash conversion bank effect. The bank effect of rent-seeking tax arbitrage is broken money conversions.
Rent-seeking tax arbitrage continues that tax-saver-signed tax bills discount tax credit value from ABCP tax bill makers, sold to ABCP holders for value, resold to ABCP holders in due course, is sued in dishonor of default, that nemo dat quod non habet excepta super protest court orders, ABCP cash conversions of taxpayer tax-saver-signed promises to pay money made for Windbills not reported in the budget.
But there's no circle of funds going through some secret account.
Allied Canadian cash flow started after bank off-site loans closings behind an official check from Allied Secret Commission pre-executed bank loans billed as bank mortgage partnership invoices that as a gullible taxpayer I contributed my income tax savings into some 15 million LIBOR interest and rent loss dollars due to tax credit Windbill revenue shortfalls not reported in the budget over 10 years until rent withholdings triggered Allied failure with its mortgage in default. Allied failure to renew its mortgage triggered credit default swaps to collect tax-saver-signed $5 million Windbills paid once in default inside a $10 million Allied REIT property flip the bank rebilled for resale in capital markets, while collecting Allied notarized unbillable bank loans with $10 million loans sued in default, as well as gullible taxpayers signed fictitious tax bills for a court order for another $5 million from Allied Windbills paid twice in default. Part 6. The court-ordered debt without trial bank effect. On March 26, 2008, I told Justice Purdy Crawford I had already paid a tax credit Windbill not in need of repayment in the Montreal Accord $32 billion recapitalization of the perfect sting my lawyer quit in court. A bank suing one forged promissory note of two commingled in an unnumbered undocumented loan for summary judgment to collect was too stressful for my lawyer to defend for trial in my storybook sleazy tax shelter scheme.
Guess what? It's not going to end until you pay what you owe.
You really don't care?
I really don't care.
And you're telling me that I have no choice?
What of a class are you? You got on it. You represent yourself now, my dear man.
Yeah, okay, well, Rob, I don't know.
You don't go either, Tony.
It's been...
You're honest, but I'm concerned. You know, you don't appreciate it. See, I do.
I do appreciate it. I do appreciate it.
Shut about this weekend, Tony. How do you think I felt having to do all those damn emails ruining my weekend?
Well, I know. I looked at the emails and I thought you must have been awfully stressed.
You're damn right I'm awfully stressed.
May 22, 2008. Justice Langdon endorsement. This motion, in reality, is simply a defense to the summary judgment now returnable May 26, To hear it today would result in a terrible duplication of proceedings. As well, Mr. Siegel has carried the file for the bank, is unavailable, and Mr. Fishoff is not conversant enough with the file to stand in his stead. As well, the material filed by Mr. Crawford is confusing and obscure. I had great difficulty ascertaining its relevance to the issues in the motion for summary judgment. Mr. Crawford should prepare a factum for the guidance of the court. June 27, 2008. Justice Harris, on reading the motion record, the affidavit of Ron Curry, supplementary affidavit of Ron Curry, the further supplementary affidavit of Ron Curry, and the compendium of Bank of Montreal, and the reply record, and the affidavits of Anthony Crawford, and exhibits, books, facts, and briefs of authorities filed by the parties, and upon hearing submissions of counsel for Bank of Montreal, Anthony Crawford, also known as Tony Crawford, appearing on his own behalf, this court orders that summary judgment is hereby granted to the plaintiff, as against the defendant, Anthony Crawford. 10 years passed in justice until January 30, 2009, when 3 appeal court judges endorsed summary judgment for the bank to collect ABCP debt without trial of its agent, noted in default to defend the Tony Crawford counterclaim. The next morning, Justice Purdy Crawford announced he had a $32 billion ABCP Montreal Accord deal on January 31, 2009. Court of Appeal for Ontario, January 30, 2009. Justices Gillese, McFarland and Lafforme, between Anthony Crawford, plaintiff by counterclaim, and between Bank of Montreal, Avalon Securities et al., defendant by counterclaim. Endorsement. Crawford could not have not known he had a bank loan. We see no error in the decision below. The essence of the defense in this matter is that the appellant failed to read the loan documentation when he initially took out the loan, or at any point in the following 10-year period when he made payments on the loan. The loan documentation makes it clear there is no genuine issue for trial in relation to the Bank of Montreal. Crawford could not have not known he had a bank loan. All that remained was clearing paid writs that the bank and a Cleaver Crawford lawyer signed releases considering the return of property seized by the bank that another judge deemed Crawford signed to discontinue an undefended ABCP lawsuit.
We've never had anybody say to us that Michael Emery would actually sign this. We never have had anybody say to us that Michael Paris would sign this. We might as well have nobody sign this except lawyers. The only people who actually sign it, who are genuine people, is me and Jill.
They're the ones that have to sign the release.
You told me that a judge would sign on my behalf.
They would never sign on your behalf. They would just make an order that's equivalent to you signing.
And how is that?
There is no defense. They would basically say that the actions are dismissed.
The wealth of our middle class has been ripped from their homes.
I have a letter here which says that you're going to sell my house.
The letter says, quite frankly, that the whole thing will be over and resolved if we just take care of this issue. It also says that. So why don't we focus on that part of it? Because if we do that part of it, there's no need for anything else. If that's not resolved, then we do have a problem and the case isn't really settled because the client doesn't have the money and they need it to close this off.
In the agreement is the acceptance of money for clearing writs, and I expect that to be done.
You don't want a release from Bank of Montreal for this?
I don't want any release. I don't want anything more to do with the Bank of Montreal.
Let's do what I told you, that I'm in agreement with your lawyer.
No, I'm sorry. You keep on going round over an issue that I don't understand. And it's one that I fail to understand. I fail to understand anything in all of this 10 years litigation. I don't understand it. It is just too incredible and beyond belief that the Bank of Montreal can write notes and then collect them. And that all evidence that I bring to the courts is simply thrown out. I just don't understand it.
Okay, I'm going to talk to the bank and see what has to be done, and I'll advise the bank that you no longer want to sign a release, and we'll see where it takes us. If that's what it is, that's what it is. I would like to get this done and figure out how to do that, so I will get back to you and let you know.
Are you telling me that when you figure out how to do that, you're referring to how you'll make me sign a release?
No.
Okay, fine.
On November 26, 2008, I met Minister of Finance, Honourable James Flaherty, about signature-specific identity theft and bank transaction numbers for consumer and taxpayer protection in case of trick loan-dependent Windbills. In March 2009, I attended a Wall Street Journal Future of Finance initiative where I gave my identity theft protection book to Gary Cohn, president of Goldman Sachs Group, in support of bank lines of regulation. Question: should there be a revival of Glass-Steagall? Should there be a separation of commercial banks and investment banks? Answer: I do not think that commercial banks should take retail deposits that they are empowered to collect and need to protect and lend them into high-risk capital market activity. In March 2012, I presented a private information for public prosecution of alleged tax arbitrage to Honourable James Flaherty, Minister of Finance Canada, and to the UK Treasury Select Committee for Banking Reform, that in the absence of bank transaction control numbers, trick loan-dependent CDS credit default swap, tax credit Windbill conversions, paper SIV structured investment vehicles to collect twice in default. Part 7. The Secret Loan Hidden Tax Credit Bank Effect. On May 17, 2008, the Toronto Star featured Canadian author William Cram and lawyer Rocco Galati suing the Bank of Canada to better serve the interest of Canadian taxpayers with its return to public use and proper account of tax credits otherwise hidden from the Treasury, not reported in the budget.
It's a constitutional challenge to the Bank of Canada and the Minister of Finance in refusing to give interest-free loans to the federal and provincial governments, which was the central reason the bank was set up initially in 1937.
This presentation is about money, which is a signed promise to pay cash from credits that a banker sues to collect private money from a tax saver in The Perfect Sting by Tony Crawford, and public money that a taxpayer sues to save from a banker in A Power Unto Itself by William Cram. Credit default swap collateralized debt obligations, signed promises to pay money, are sued to collect private loonies from tax savers, as well as public loonies from taxpayers, which is the twice-paid tax credit Windbill conversion theory.
The other part of the challenge, which goes hand in hand with this whole banking fraud that's going on, is against the Minister of Finance and the budgetary process. The speech from the throne is a constitutional requirement before the budget is actually passed. Problem with the budget in our country is there's a sleight of hand that goes on.
In 2012, Anne Emmett asked for my support as expert witness of bank system design, and I met William Cram in court December 10, 2013. William Cram was founder of COMA, Committee on Monetary and Economic Reform. Anne Emmett refers to COMA, a former think tank, as chair of a litigation steering committee of individual taxpayers under the acronym name of COMA, Committee for Monetary and Economic Reform.
The English House of Commons talked about how money was created lately. I think Ukraine is doing that same thing, and a few other countries have just announced that same thing as well. So what can we do as supporters to try and get this to be heard and to be a public issue, to try and get this national coverage?
Well, we were a think tank, but now there are so many tasks to be done. Comer is planning to work at two levels, the level of coalition and the level of community.
On October 14, 2015, Rocco Galati argued an amended claim about the cost of money and losses to tax credits not reported in the budget.
The Minister of Finance has given to a group of private bankers in Basel, Switzerland, the right to tell what the Bank of Canada should do. And the Minister of Finance, under the Bank of Canada Act, is the shareholder of the shares of the bank and trust for Her Majesty the Queen. I mean, it can't be clearer than that. Parliament can be as nincompoop as they want, so long as they don't inflict constitutional violations.
Very reassuring. Thank you.
I know, but that's the law. However, that's not the case before you. The case before you is that there is an executive breach of a constitutional requirement by the Minister of Finance with respect to the budget process. And that as a result, the legislation that comes out of Parliament breaches the constitutional right to no taxation without representation. Why? The MPs are blindfolded. By removing and not revealing the true revenues to Parliament, which is the only body which can constitutionally impose tax and thus approve the proposed spending from the speech from the throne, the Minister of Finance is removing the elected MP's ability to properly review and debate the budget and pass its expenditure and corresponding taxing provisions through the elected representatives of the House of Commons. The right to vote includes the right to effective representation. If the MPs are blindfolded by executive constitutional breaches by the Minister of Finance, how does that ensure effective representation?
So, my submission to you is what could be more important to Parliament's functioning than the debate of the budget, process of the budget. And that's why in our Constitution, it's very clear in the Constitution Act 1867 that it must be in the House of Commons.
So in blunt terms, if you're telling me a Parliament wishes to act in an incompetent way, that's up to Parliament.
Well, Your Lordship is certainly using blunt words. It's not for me to say whether these are many...
I'm pitching it at a hypothetical.
Yes, exactly. That's right. I would prefer that. As an officer of the Crown, I would prefer that. Let's put it this way. It's like this idea of parliamentary intent, which we all search for when we do charter analysis. And there's a great British jurist who said, that's really a will-o-wisp. They all have various intents, those individual members who are representing their ridings. And they may have different intents at various steps, at various, first reading, when it comes back from committee. So I guess what I'm trying to say is that it may not have seemed so to those members. But the way our Constitution works is they make the laws. Once the laws are on the books, our judiciary scrutinizes them for conformity with the Constitution. But wisdom is not something that... Wisdom of legislation is not in the bailiwick of courts, as I understand it.
So if a bill comes before Parliament and the information is defective, there's not enough information there to make a meaningful decision, the remedy is what you're telling me is...
Well, I guess the remedy is that we have elections every... at least 5 years, the Constitution mandates. So the remedy would be is that people would vote in a party that would pass a different law.
So you're saying if Parliament wishes to pass legislation without having the full wherewithal, the full knowledge of what that legislation is all about, that's okay?
That's up to Parliament, because my next point is that Parliament is supreme in its deliberations.
Federal Court Decisions, February 8, 2016. This is a motion by the defendants under Rule 221 to strike the plaintiff's amended statement of claim, March 26, 2015. The plaintiff, Committee for Monetary and Economic Reform, CUMA, is an economic think tank based in Toronto. CUMA was established in 1970 and is dedicated to research and publications on the issues of monetary and economic reform in Canada. The individual plaintiffs are members of CUMA who have an interest in economic policy. As set out above, I do not think that, even for the declaratory relief sought, that the plaintiffs have been able to raise their claim above a mere request for an advisory opinion. Without having any real legal interest at stake, the plaintiffs remain a think tank, seeking to have the court endorse their political and academic viewpoint. This court orders that the plaintiff's latest amended claim is struck in its entirety, leave to amend is refused, costs are awarded to the defendants. On the May 7, 2015 CBC Exchange, lawyer Rocco Galati said he hopes the Bank of Canada case will result in a court order that members of Parliament will be bound by its legislation.
No one is underestimating Gulati in his latest fight over the Bank of Canada's business. His cases can seem improbable.
In this case, what is your hope? What changes post the ruling that you're hoping for?
My hope is that the court declared that the government is bound by the legislation and cannot simply hand over that decision-making to foreign private bankers.
Ann Emmett, chair of CUMA, Committee for Monetary and Economic Reform, still appears on side William Cram for his day in court.
Show whether the law works or not. We have to show the difference between what is legal and what is just, when what is legal is not synonymous with what is just. And when the law doesn't work, then we have to politically change the law.
On December 7, 2016, the Federal Court of Appeal upheld against CUMA as a think tank that William Cram was denied his day in court. On December 7, 2016, the Federal Court decided against trial of broken money rules that an advocacy group cannot use declaratory judgment to promote a political point of view in case of tax scams for the rich. Federal Court citation December 7, 2016. The appeal is dismissed with costs. Reasons for judgment. A declaratory judgment must be more than hypothetical and requires a cognizable threat to a legal interest before the court will entertain the use of its process as a preventative measure. The court is not here to declare the law generally or to give advisory opinion. The court is here to decide and declare contested legal rights. Part 8. The Supreme Court of Canada Bank Effect. On December 7, 2016, William Cram said he would take the verdict of the Federal Court to the Supreme Court of Canada. Rocco Gulati for CUMA wrote Eric Bichwam if a motion for an assessor and bank technology was filed, CUMA would sue for it purged pursuant to Federal Court Rule 74. Then, on December 16, 2016, Eric Bichwam served a motion to reconsider what is CUMA in the action. In the CUMA case against the Bank of Canada, Eric Bichwam wrote letters and filed motions requesting court appointment of an assessor. The Crown opposed these motions as irrelevant and vexatious, and CUMA sued to have them removed. In over 8 years, a lawsuit about foreign cost of money and unaccountable tax losses questions the Supreme Court of Canada. Is CUMA a corporate citizen with legal vested interests for trial, or a body politic misusing the court for endorsement? Federal Court of Appeal, December 16, 2016. Motion to reconsider pursuant to Rule 397. Overview. The appeal is about citizens' rights to enjoy constitutional behaviours without need for causal actions, in this case for a clarification of bills of law that govern monetary issues and economic policy in Canada. That especially a declaratory judgment is required as a preventative measure in case of criminal acts that outdated laws from 11th century judicial systems are plainly not applicable or enforceable in business affairs of the 21st century. Specifically, this motion is to reconsider the verdict to ensure court awareness of real parties behind the action being individual taxpayers, and the motion for assessment is to understand the sovereign debt position after comparing public Bank of Canada onshore cost of money to actual offshore cost of LIBOR to print Canadian onshore legal tender, and interest and principal costs of the tax credit payments offset to government distributions of public wealth into private enterprise over the period specified in the original claim.
Show whether the law works or not. We have to show the difference between what is legal and what is just, when what is legal is not synonymous with what is just. And when the law doesn't work, then we have to politically change the law.
A lot of my stories get covered wall to wall nationally. This story is much bigger than any of them.
and it has not been covered by one single mainstream media. Yeah. I'm sorry, he was...
If you get Supreme Court permission to proceed, where do you start again? Do you have to go back down to the provincial level, or you
No, it's in the federal court trial division. We go back to the federal court.
So it goes back to the federal.
And then we start the procedure of filing our documents, discoveries, and trial. Yeah.
Okay, thank you.
What can we do as supporters to try and get this to be heard and to be a public issue?